Thank you, Mr. Chairman. Thank you for your testimony. I hope you'll take these questions in the spirit that they're given. I'm not looking to play gotcha at all. I've been supportive of these negotiations. I commend you all for the hard work that's been done. But there is some disagreement here, it seems, with the text of the agreement as we read it and the explanation that's given. And let me just cover a couple of these points. Number 8, on adoption day here in the annex for the implementation plan, it says Iran will officially inform the IAEA that, effective on implementation day, Iran will provisionally apply the additional protocol pending its ratification by the parliament, the Iranian parliament, and will fully implement the modified Code 3.1. We've talked about the agreement, although it's voluntary, to live by the additional protocol. What happens if the Parliament, first, what is the timetable that's required for the Parliament to address the additional protocol?
They have, Senator, they have to live by the additional protocol from the moment of adoption.
Understood, but
they
going forward...
They have 8 years, within 8 years, to adopt it formally but they are in material breach as of adoption day if they do not live by it. And it is fully understood by everybody that would be a material breach.
But there is no timetable where the Parliament has
to... They have to do it within the 8 years.
Within the 8 years?
Yes.
Okay, so that's the timetable. Second...
which is before the sanctions are lifted. So you have the snapback capacity as a result of their not doing it.
Understood.
Or living by it.
Understood. In December of 2011, the President signed into law the NDAA that included sanctions on Iran's central bank. These sanctions penalized foreign financial institutions that were doing business with Iran's central bank. These sanctions will ultimately be suspended because of the JCPOA. What I'm trying to understand, and this keys off a question that was asked by Senator Cardin and others, according to the agreement, the U.S. administration, acting consistent with the respective roles of the President and the Congress, will refrain from reintroducing or reimposing the sanctions specified in Annex 2 that it has ceased applying under the JPOA without prejudice to the dispute resolution process. This is what I think a lot of us are having a hard time reconciling here. What would constitute reintroducing, reimposing sanctions specified, existing sanctions? If, because Iran didn't violate the nuclear part of the agreement, but for other reasons committed terrorism abroad, abducted Americans, and we wanted to penalize them, we wanted to sanction them, could we impose sanctions on Iran's central bank? Because that would mimic or be similar to what was done before, but it would be in a different context. Would that be allowed, or would that lead to some violation on our part of the agreement? Secretary Lew.
Yeah. I'm going to take a stab at this because we've been going around on it, and I want to try to, if I can, answer it dispositively. First of all, we will not violate the JCPOA if we use our authorities to impose sanctions on Iran for terrorism, human rights, missiles, or any other non-nuclear reason. And the JCPOA does not provide Iran any relief from U.S. sanctions under any of those authorities or other authorities, mind you, and I'll go through some of those other authorities. What we have committed to do is quite specific. Iran was fearful that, having witnessed the hot desire within the Congress for more sanctions, that even if we cut an agreement, you folks might just turn around the day after and say, oh, too bad, we're coming back with all the same sanctions. And then the president's in veto status or override status or whatever. So what they really wanted was a clarity that we're not going to reimpose the specific nuclear-related sanction provisions as specified in Annex 2 to the JCPOA, contingent on them abiding by the commitments of the agreement. So it's really simply a clarification to them that we're not going to come back and just slap them on again. But that absolutely does not mean we are precluded from sanctioning Iranian actors, sectors, or any actions if circumstances warrant. So all of our other sanctions authorities remain in place. They're unaffected by this agreement. And Iran only said, if you read what it says, that they would treat the imposition of new nuclear-related sanctions as the grounds to cease performing. But they are clear, and we are clear, that we have all other kinds of authorities. And let me be specific on that, because it's important for this whole debate to be clear. Even with the lifting of sanctions after 8 years on missiles or 5 years on arms or the UN sanctions, it's only the UN sanctions. We still have sanctions. Our primary embargo is still in place. We are still sanctioning them. And I might add, for those things that we want to deal with in terms of their behavior, for instance, Hezbollah, there is a UN resolution, 1701, that prevents the transfer of any weapons to Hezbollah. That will continue, and what we need to do is make sure we're enforcing it.
I think we've got that. I just want to make sure that if we say, all right, what was effective on Iran, what really has brought them to the table more than anything else, in my view, are these sanctions on the central bank, because it's more difficult for Russia, China, and other actors to help them evade these sanctions. If we decided, if we want to impose penalties to deter them from terrorist activity, and we impose sanctions on their central bank, that won't be a material breach of the accord.
No.
That will not. All right, one other question on the broader topic. Assuming this goes into effect, we're going to desperately need, a regional security framework that you've touched on, and some discussions are already going on. I would just encourage you that I understand the problem with 535 secretaries of state. We can't have that, but I would encourage you to reach out to at least the relevant committees here as that framework is put in place to make sure that it can endure longer than just the first couple of years in an agreement. We all know that to have the institutional fortitude to move ahead, it's best to have Congress involved. And there are many points between 535 secretaries of state and proper consultation with the relevant committees, at least, of jurisdiction here. And so that
I couldn't concur more, Senator. I think you're absolutely dead on. We agree. And by the way, I think in the course of this negotiation, prior to the passage of the requirement for the 60 days, which we understand and joined in with, working with the chairman, and we're grateful to the chairman for the cooperation on that. But there were a huge number of briefings and hearings and telephone calls and meetings and so forth, literally in the hundreds. But I come back to this. I couldn't agree with you more about this new arrangement. We are talking about arms transfers, about special operations training, about counterterrorism, counterinsurgency. We have a major need here to build capacity in many of those countries. The Gulf states spend about $130 billion a year on their defense. Iran spends $15 billion. Yet you see a disparity in terms of what's happening within the region. That has to be addressed, and that's the purpose of our initiative.
Thank you, Mr. Chair.